decided we really needed alternatives to resolve disputes. We couldn't go to trial in every case. It was just impossible to do that. That there had to be other mechanisms for people to resolve their disputes. The only thing we had at that time, and as I said, I've been practicing for going on 27 years now, really the only thing that was available was to pick up the phone, talk to the other lawyer, settle on the courthouse steps. So what happened was a process was developed and rules were developed to implement a mediation process here in Florida. And now it's pretty much throughout the whole country, but Florida was a leader in that process. Mediation, as opposed to having a case decided by a jury or a judge, by a third party, mediation is a process whereby the parties themselves decide how a matter is settled and resolved. They come to a mutually agreeable decision that they are willing to resolve that particular dispute. You know, there are conflicts that people have, and there are a lot of reasons for conflicts, as you all know. It's either, you know, emotions, it's power related, it's lack of information, it's just a whole host of things. So it's important when there is a conflict to try to figure out what the underlying reasons for that conflict are. A lot of times we don't think about it, or our emotions overcome us so much that we really are blinded to logically evaluating why there's a conflict. So it's always important to consciously be aware of why that is going on. You have to step back, evaluate it, step in the other person's shoes, evaluate why they have an issue, and then try to come up with a solution. That's very critical. Sometimes that conflict cannot be resolved before a dispute arises. The actual dispute that is filed, whether it's in a particular forum, in a court of law, what have you. So again, it's very important sometimes to resolve conflicts before they evolve into a formal dispute. In Florida, what we have in our particular process is that if a case is in court, parties can elect to have a mediator assigned to that case voluntarily, or have a judge assign a mediator to meet with the parties. And just briefly, in a nutshell, a mediation in court is where the parties meet with their lawyers, the mediator talks to them about the case, the parties make their arguments, and then what happens is what I call shuttle diplomacy. The mediator meets in private, that is called as a caucus, with the other party and their lawyer, talk about the issues, go back and meet in private with the other party, and they try to come up with mutually agreeable solutions to that dispute. And it's a very interesting thing. What I try to teach my students is that you can never take mediation for granted. If you have a client and you're going to mediation, never assume that that case will not settle at mediation. The reason I tell them that is because the dynamics of mediation and the chemistry involved that is created by that process can result in the settlement of a case that the parties thought would never get settled. I've seen it happen. And so what I tell my students is that this particular process could be your trial. So you wouldn't go to trial unprepared, so you shouldn't go to mediation unprepared. If you do, you're doing a disservice not only yourself, but more importantly your client. And the reason I say that is that because when you're in that room, if you have not properly prepared, just like if you have not prepared for one of your classes, the students are going to be, you know, adversely impacted because they're not going to learn everything they need to learn. But in the mediation arena, what's going to happen is that one of the parties will leave something off the table, will forget about it, and it will not be memorialized into an agreement that's binding. And the last thing you want to happen is to walk out of that mediation room as a lawyer and think, wow, I just forgot to include something in that agreement. Because many times it won't, the other party's not going to agree to have you put it back in later. Because again, it's a contract. Once that mediated settlement agreement is signed by all the parties and the mediator, in essence, it becomes a contract. And so it can be enforced in a court of law by the court. And I've been involved in that process before, where the courts had to enforce a settlement agreement because it is a contract. So that is, in essence, the mediation process here in Florida. It's a good system. People say 60 to 70% of the cases get settled at mediation. I've looked at the statistics. I think it's less than that, actually. But I think what happens is that the parties, if they don't settle at mediation, are able to better evaluate their case, and sometimes those cases get resolved later. So the mediation does have an impact. Importantly, though, I think it's also critical to note that there are some cases that are not appropriate for mediation. And I think the lawyer has to really make that decision. Is this a case that should be mediated? There are public policy issues sometimes that need to be adjudicated by the court, and some of those cases may not be appropriate. But again, that's a decision that has to be made by the parties and by the lawyers. So those are things that have to be at least looked at and evaluated. The system itself has been a good one here in Florida. To become a mediator, you have to apply, take a class, usually through either the American Arbitration Association or another organization. It was a little different when I took the class in '95. I went through the AAA course, then I had to do 2x2s, which were actual mediations with a mediator. Then I applied to the Supreme Court and I was certified. Every 2 years we have to have CLE credits to maintain our certification.